Hi, everyone. Harry here to talk about the administration's response and pushback against the motions by James Comey and Letitia James to dismiss the indictments against them because they argue Lindsey Halligan, the hand-picked U.S. attorney slash insurance lawyer for Trump, wasn't validly appointed to her position. All right. Point one. The law here is quite convoluted and involves the interplay between a few different statutes. But point two, the easiest way to understand at the top level is that the law is about keeping the administration from making an end run around the Senate's prerogative to confirm U.S. attorneys. U.S. attorneys are an inferior officer under the Constitution, and it falls to the Senate to confirm them. And obviously, there have been instances in the past where the administration has tried to pull fast ones for certain controversial candidates, and that's why the legal scheme is there. And point three, the other courts that have considered the identical motions, near identical, different U.S. attorneys, but Alina Habba in New Jersey, the guy they've tried to appoint in L.A., both have held that the administration erred and that the appointments were invalid. Okay, so let's go a little bit more to the merits. And again, just keep in mind, this is to require the U.S. to submit U.S. attorney nominations to the Congress. Now, that hasn't happened for almost all of the positions in the Trump administration, and they're happy to just have non-confirmed people doing their bidding as long as they can do their bidding. And indeed, that's the very problem. With Lindsey Halligan, for example, the guy who was set to be nominated by Trump refused to bring the cases against Comey and James. They weren't there, and it was an absolute travesty that they fired him and then said, I know. Good old Lindsey, my former insurance lawyer who has not an hour of experience as a federal prosecutor, you're the new boss of the office. Go in and get these indictments. And the argument, to sketch it out just a little, there is first an interim appointment. That's what that previous U.S. attorney had. That's what someone else had in New Jersey. It lasts 120 days. And after that, the statute says it falls to the district court to make the appointment. That's a provision that the U.S. has fought bitterly already in different cases. Here, what they're trying to say is, again, against the rulings of the other courts to have considered it, yes, there's an interim appointment of 120 days, but guess what? You restart the clock with each new person. And therefore, Lindsey Halligan is, back in a safe harbor of an interim appointment. But, the argument against that is very strong, because what it would mean is the U.S. could just stack up interim on interim on interim appointment and never have to submit their choice to the Senate. But that's their first statutory argument. And their other argument is there are actually two or three or four kind of, and which is a strong indication that they're flailing. But the other trick they've tried to pull here is to say the court can make the appointment, but it doesn't say the attorney general can't. And here you have a piece of paper that they've submitted that Pam Bondi signed, appointing Halligan a special attorney. Isn't that special? And as a special attorney, she can do this stuff anyway, so it's sort of no harm, no foul. Special attorney is kind of an all-purpose designation. It's actually the one I held when I practiced when I was at Maine Justice. They let me do some trial work also in the Eastern District of Virginia, and that was my designation, Special Assistant U.S. Attorney. And they've called her now, well, so it's pretty similar. They've called her a special attorney, and they say that that's Okay. All right. So those are the statutory arguments. And given how they've come out in the other courts, and given that they would plainly permit the U.S. to circumvent the statutory scheme, they seem pretty weak. The point here is once the interim has run, U.S. get your act together and submit your nominee to the Senate to go thumbs up or thumbs down on. And if it's thumbs down, then submit someone else. But we're not supposed to be playing around anymore with interims and the like, which is exactly what they're trying to do. Okay. So these various not very strong arguments are then their whole second half of the arguments is on remedy. So James has said dismiss the case, but not with prejudice. She has asked for certain sanctions against Halligan and the DOJ, but she pretty much isn't trying to make it go away forever. Comey is different. Comey has said dismiss with prejudice. And so what the U.S. is trying to dig in with against Comey is to say that there's not bad faith, and that's what you need. Of course, the whole big point here with Comey is Halligan was rushed into the grand jury on the last day or before the statute of limitations would run, or the last couple days. So if this is dismissed now, I don't see how they restart the engine because it's now been, I think it should be time barred. We'll see whether they have a creative argument that you can somehow relate back. Okay, one final interesting point. The judge who is hearing these motions to dismiss, a judge, not Judge Nachmanoff, but Judge Curry, a senior district judge in South Carolina. He's hearing it because Judge Nachmanoff, and this was the same thing judges in the Haba and other cases decided, it would be the appearance of a conflict because he daily encounters people from that office and sitting in judgment over who's in charge, I think looks awkward at a minimum. So they've served it up to the senior district judge. And that senior district judge has said, I want all the transcripts from the grand jury to see what happened here. And, remember, Lindsey Halligan, not a whit of experience, goes to the grand jury after, I guess, they point her the way, and with marching orders to come out of there securing the scalps of Comey and then James. God only knows how she handled herself, what she said. This is something, you wouldn't do as a new prosecutor for a year or more, and then you would do it with another person. She did it alone. Anyway, he ordered the transcripts from the grand jury, and they submitted the transcripts, the administration, except for the transcripts of what Halligan said. They just excised that and just had what the witness said. So the judge immediately said, no. I want to hear Halligan and everything she said in the grand jury, everything she said when presenting the indictment, and I want it by tomorrow. And we'll see. I'll bet it's some really at best embarrassing and at worst really improper stuff. She doesn't know what she's doing, and B, she's got to get the indictment. So it could be really ugly in there. We'll see. And we'll see, in fact, how much the administration is trying to keep it from under wraps, because obviously it was a ham-handed move to submit everything, but not her statements, which were clearly covered by his order. And maybe they're so ugly, we'll see the administration run now up to the Fourth Circuit to try to reverse that part of his ruling, which it'll be very interesting either way. It'll be a suggestion that, man, oh man, this is not pretty. And if it comes out, it will be very illuminating about the sort of almost Alfred Hitchcock nightmare of a complete amateur being pushed into the grand jury to get a high-profile indictment of a very senior former official. So that's the next mini drama coming in this aspect of the case involving Halligan's appointment. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.